Hi, I'm Jack Fishman,
I'm Ann Miller.
and we're with Fishman Miller PC, attorneys at law.
Fishman and Miller. So the will is the legal document that gives the authority to pass something from someone who is deceased to someone who is alive. That's what the probate process is. The will is what gives your executor, gives your family the authority to make sure that who you want it to go to goes the way you want it to go.
And who's an executive?
So the executor is a person that you trust, and the executor is going to be the person who gets the legal authority from the court to make sure that your possessions get passed on to those that are left behind. If your estate is less than $100,000, then your property can be passed without going through probate. If you have a will, that helps because you will do what's called a small estate affidavit. The small estate affidavit would be filled out and with or without a will, and that's just a way of avoiding probate. That's not a way of avoiding having a will. But if you didn't have a will and your estate was less than $100,000, let's say you had a car and you wanted to pass your car on to a grandchild or on to a daughter, you would use a small estate affidavit to do that.
Can you pass any property with a small estate affidavit?
No, you cannot pass real estate property with the small estate affidavit. So if you own your house and it's not in a trust and it is only in your name, on your death, that becomes an asset that has to go through probate. Using a small estate affidavit, for example, if you have a bank account and you are the only person on that bank account and you pass away, your executor or your personal representative would take that small estate affidavit to the bank in order to get your bank account, your funds released to you. If you don't have the small estate affidavit, then you need to go into probate to get letters of office for intestate, which is an estate that does not have a will. Let's talk a minute though about the younger generation. Oftentimes we're looking at people that are closer in the circle of life towards the end of life. And we're thinking that the elderly, those are the ones that need to have a will or a trust or do their estate planning. Young people who are turning 18, the law looks at someone who's 18 as being an adult. They may say, 18, what do I have? I've got nothing. Maybe I have student loan debt. Why would I need a will? Well, what happens unfortunately is tragedies. We never know, 18 or 80, if there's going to be an accident, if someone's going to lose their life, and now there's an estate that might have a lawsuit for a wrongful death claim, for an insurance claim. Without that will, without that 18-year-old or 20-year-old or 80-year-old saying how I want my estate to go, it becomes a court battle. It's more than just, I want my favorite teddy bear to go to my brother. It's more, who's going to take my body? Who's going to see that my body is buried or cremated or recycled the way that I want to have it
And
done.
maybe the executor in the will.
The executor in the will. It's important, regardless of what age, to have a will. When you're doing your estate planning, the will is only one part of it. The next aspect, or something that goes hand in hand with that will, is a trust.
What is the difference between a will and a trust?
So let's first identify the different types of trusts. There's grantor trust, there's non-grantor trust, there's revocable trusts, irrevocable trusts, living trusts. So let's talk about the most common, which is a revocable trust, also called a living trust, also called a grantor trust. For purposes of just talking here and with estate planning, as far as the IRS is concerned, it's a non-entity. You're going to have a trust, it's going to use your social security number. You can revoke it, amend it, change it at any point in time, provided you still have the capacity to do so. Most people use a trust as a means to avoid going to probate. It's a way, again, of passing their assets on to a husband, wife, children, grandchildren, without going into court. It's also a way to have your estate, your assets handled if you become incapacitated.
So a trust could work while you're alive, or it will only works on your death.
Correct. A will, again, can be changed up until the time of death, but a will does not come into play until time of death. A trust is called the living trust because it's during your lifetime, and then it can also continue after your death. You will have a trustee. Most normally, you're going to be the trustee of your trust during your lifetime. There may come a time when you can no longer act as your own trustee, and so your successor, the second trustee, takes over. On your death, the second trustee takes over and just passes things on or holds them in trust. So let's say you have a child who's a special needs child, or you have a child that you're concerned about. If they get divorced, is that spouse going to take that money? Or they're a recovering alcoholic, and you don't want them to get money right off, because what will happen? So your trust can have a trust within a trust to provide for the health, education, and welfare of your child, your grandchild, and protect any type of an inheritance that you would pass on to them. If you're doing a will and a trust together, your will is called a pour-over will. And the reason why it's called a pour-over is if you imagine there's a bucket, and in this bucket it's got all your items. It has your couch, your dishes, your house, your brokerage account, your savings account, and it's all in this bucket. And so what you've done is you've titled many of these different things into your trust. But there's a couple of things that are left over. Maybe you forgot that bank account. Maybe you forgot that couch. So what the will does is it pours everything over into your trust to be distributed the way you set it out in your trust.
So you've talked about a will, you've talked about different kinds of trusts. Isn't a living will the same as a will?
No, a living will, it's a document that says, give me a feeding tube, don't give me a feeding tube, or let my agent make that decision at the time. The living will helps to give your family direction on how you want to be cared for at end of life.